Hello and welcome to the Herrington Carmichael Employment Law Update for September 2019. I hope you've had a good summer. It's now back to it with the 4 key subjects in employment law from the last month. So where do we start? We start with holiday pay and the case of Brassel and Harper. This case related to the calculation of holiday pay where an employee is not working the full period of a holiday year. Now, with casual workers, lots of employers use a 12.07% multiplier to calculate the amount of holiday, and this was applied in this case. However, the claimant argued that actually what should be done is a calculation over a previous 12-week reference period prior to them taking holiday. The claimant was right, and that meant that there was an uplift in holiday for the worker who was only working part of the year, and actually they ended up with more holiday than the equivalent full-time employee. What's the learning point? The learning point is if you have employees who are only working part of a holiday year, make sure you calculate it on a 12-week reference period rather than applying a percentage multiplier. Also, look very carefully at holiday pay calculations and do check them against the working time regulations to make sure they're absolutely right. Next this month we have the case in relation to illegal working and a situation which is very sad where an employee lost her rights in relation to her visa and was then found to be illegally working. Her employer treated her very badly and only paid her a very small sum for the period of time that she worked. She pursued a claim and the employer tried to argue that the contract was illegal and therefore was not a claim that could be enforced. This illegality is a defence that employers can use. However, the courts held that both the claimant and the respondent needed to have knowledge of that illegality. Otherwise, they would allow the employee who had been treated badly to still pursue a claim. And in this particular case, which is very specific on its facts, the claimant didn't actually know that they were working illegally. Now, what does this mean in practice? This means in practice that the illegality defence is actually quite narrow, and what that means, if you're intending to rely upon it, or an employer is trying to rely upon an illegality, you need to be very, very careful and always take advice. Let's look at whistleblowing. We're seeing lots of clients wanting to talk to us about protected disclosures and whistleblowing. And the question in the case of Okuwu and Rise Community Action was the question of reasonable belief of whether the whistleblow was in the public interest. This case held that the assessment of whether there was a reasonable belief needed to be taken from the perspective of the claimant rather than generally. In this case there was a complaint about data protection and the employer tried to argue this was only in relation to the employee's own data protection rights, but actually when it was looked at from the employee's perspective it had a much broader application. What this means is that employers need to look very carefully at the mindset of the employee when they're making that protected disclosure as to whether or not it is a qualifying disclosure. Finally, employment tribunal proceedings. Now this may seem really obvious, but this employer got caught out. In the case of Upton Hanson and Architects in Giftcake, this case related to a constructive unfair dismissal claim where the employer tried to argue that they had a fair reason to dismiss the employee. However, the employer didn't actually properly plead as part of their employment tribunal particulars the fair reason upon which they relied. A general denial of the claims was not sufficient, and the courts held, or the tribunals held, that actually what the employer had to do was properly plead out the reason upon which they were saying they fairly dismissed. What does this mean? This means in practice, if you're defending tribunal claims yourself, you need to be really careful about the particulars that you're putting in and make sure it's absolutely clear the reasons you're relying upon. General denials don't work. It's always sensible to take legal advice in relation to employment tribunal claims, and we'll always be more than happy to assist. That's it from me this month. I'll be back to you in October, and until then, I hope you have a good rest of your day. Thank you.